Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Looking at a book on Chinese law, another one, yes. This book is from Edward Elgar Publishing Limited, an independent publishers. They produced a whole series of books which I think are invaluable as China opens up its unknown potential to the rest of the globe, and we're looking again at Chinese law. This book is one of a series of books. We've actually reviewed others in the series. It's the Renmin Chinese Law Review. It's selected papers of the Jurist, now in volume 3, and it's been edited by Jichun Shi. And as I say, it's by Edward Elgar. There's an electronic version available on the Elgaronline Law site. It's also an ebook as well, and there's all the referencing, which I'll show you in a minute in the actual book itself to find what you would be looking for. We've given it a title for our review, our book review, of Serious Recommended Reading for All Interested in Chinese Law. And that's really what it's about, because Chinese law is not understood by many people, and it's an important developing area. You can see the book here. There's the front cover, and then there's the spine, and then there's a little bit of information basically at the back, explaining who the author is, Professor of Law at Renmin University of China Law School in China. Now, the book, let's go to the back of it first of all, runs to something approaching under 400 pages. There's quite a detailed index right at the back. Then, before then, you've got the various articles. And what I like about this, there is footnoting. You do have subheadings which are numbered. You don't have paragraph numbering in the same place, but you as you would in main textbooks, for instance, but you do have the footnoting, and it's not overdone, which I think is quite important to bear in mind. Now, here is the front page you've got there, and then there's some detail about the previous papers which have already been published, and then you've got the detail about the electronic Elgaronline side there. Then you've got the actual contents which are set up, and the various authors who have been contributing. There are 13 chapters in total. Then there's the index at the back, and then the list of the contributors there. I can't go through all their names, but they're all very highly qualified people. That continues there. Then there's a preface with an introduction as to what this is all about, and then of course we go through there and then get into the first of the effectively essays, their contributions. Explains where it's come from right at the beginning. As always, it's very much the standard structure. And again, I think you do have, for this book, as with a number of them, you do have to have some knowledge of Chinese law and what's happened in China itself, and have some understanding of what is perhaps going to happen in the future. And that, of course, is extremely difficult. It's a very big market, and it's an area which we don't in the West know that much about in real terms, in terms of publicity and so forth. So I think this book is an excellent contribution to anybody who's interested either in Chinese law or how it's going to develop over the years, because there have been attempts to run Chinese law subjects in various law schools and so forth, but at the moment we still haven't really moved much in that direction. And it's really, I think, a question of seeing how China as a country starts developing in this century, because at the moment it's clearly poised to be one of the major players. Just takes them, say, to land something on the moon before too long for the Americans to start probably realizing that they have very major competition in that particular area in terms of markets, certainly. Of course, you've also got the whole issue of the political concepts as well, which of course do come into it. And what I'm suggesting is that you do need to be aware of the approaches of the different sort of countries and the different people who are involved to know what you can and can't do, and in fact where there are areas of interest, if I can put it like that, in terms of things like the rule of law, binding decisions and so forth. Anyway, let's talk about what we say about the book from our review. International lawyers will almost undoubtedly be grateful to Elgar for the series of annual volumes on contemporary Chinese law, of which this is one. This book is the third work in the series, which, in featuring the work of Chinese legal scholars, promulgates valuable insights into current legal research in China, and most significantly into the workings of Chinese law. Now, as I've said before, I know little really about Chinese. I've got some basic principles, and I did find it quite hard to follow some information, but you've got to persevere with it, and in fact it does actually open up a very new and enlightening area for, I think, any jurisprudent. The book is a collection of 13 learned essays and articles from 20 of China's top academics on various aspects of Chinese law across an amazingly wide range of issues, many of which will exert a significant impact, not confined solely to China. And all the articles are on current and topical issues, with 2 of them offering particularly interesting insights to Western readers. For example, the article by Wu Guangrong entitled Impact of Administrative Approval on Validity of Contract, Theory and Practice sheds considerable light on contract law as it is understood and administered in China. That internationally must be of importance to us. Initially, the meaning of administrative approval, it is obviously a question of what does that mean? It's not altogether clear. However, it eventually is explained that administrative approval is a state's supplementary declaration of will upon independent legal acts concluded by parties. So we're looking at it, I think, if I may suggest, in a slightly different way, and we've therefore got to compensate for that when we understand exactly where they're coming from. Apparently, if there is a problem then, or problems in this regard, the author expresses the view that the place for examining the validity of contracts is the People's Court. And effectively that's what's going to happen in this country if you have an issue concerning the validity or otherwise, the status, in other words, whether it's void, voidable, unenforceable or illegal or whatever. You've got some idea quite quickly that it will actually have to go to a tribunal or court for some sort of decision. So it will effectively, notwithstanding anything else, be a matter of interpretation. I think really that's the essence of what comes out of that particular example. A number of rulings on this particular area and other related matters are discussed in considerable detail in the book. And it's mentioned here that according to the judicial interpretations, the contract without administrative approval is defined as an ineffective contract, distinguished from the effective contract and the invalid contract. So what they're doing, if you go back to your principles and elements of law of contract in English law, you can see they've got different words, but probably the outcomes are fairly similar, although they probably don't have the voidable concept in the same way that we do in English law, which of course is essentially, if you think about it, more of an equitable remedy in that sense. So as a contract is a fundamental concept, this glimpse into current thinking in China regarding contractual issues is illuminating, and for the international lawyer, I think, and jurisprudent, a most and very useful pointer in the direction they're going in. Another article of note is by Huang Deming and Zhang Cheng concerning the future of the increasingly warming Arctic regions. Again, a complicated, controversial area. Major implications, of course, for future disputes on exploration and exploitation of the natural resources there. Essentially, the article is a minutely detailed examination of issues relating to geographical boundaries, the often disputed concept of the continental shelf, and so on. And much reference is made to the provisions of the UN CLOS setup, that is the United Nations Convention on the Law of the Sea. Now, we probably will recall we've had conventions in the past on the law of the sea, and frankly, I have to be blunt, I don't know whether we've come off very much better out of it. It's a little bit like concerning what the law of space is. If you're talking about setting up, for instance, a European lunar village or something like that, which is quite possibly going to happen within the next 15 to 20 years, you're then starting to look very much at the legal implications of that for international law purposes. And again, like the law of the sea, they can have conventions and conferences and so forth, but the question then is, what have we actually got out of it at the end of the day? Do we actually have, through the UN, something that's binding on people, or as binding as it ever can be within any treaties that countries make with other countries? Anyway, the title indicates the scope of the discussion. That's why I find it really enthusiastic as a sort of concept to start looking ahead and saying, well, these are the areas that they're involved in, and this is the sort of thing we should be talking about ourselves. For instance, there's another one on issues of delimiting outer continental shelves beyond 200 nautical miles in the Arctic seas and the construction of the Arctic regional legal system. So you see, these are areas even now. I mentioned space a few minutes ago, but you've still got issues even confined to this planet, where there are still really very largely things that have not been agreed. They're unagreed, if you like, in that sense. And so it's something that obviously the Chinese are raising, and something we should be considering in the West. As is pointed out, of course, Russia, Canada and the US, plus most of the Scandinavian countries, are involved in this and are here referred to as the Arctic states in terms of political geography. Also pointed out are the legal debates which target, quote, the huge potential resources of the Arctic, which have increasingly heated up. The significance here rests on the ownership and allocation of these resources. Therefore, let's hope that the inevitable future disputes on these issues will be confined merely to legal debates. Obviously, one is aware of the Russian interest here as well, so it isn't very much of an international matter for us to keep a watching brief on. Let me conclude by saying that obviously this particular volume, volume 3, as well as other volumes in the series, comprise a valuable find for lawyers, scholars and policymakers everywhere who, wishing to enhance their understanding of Chinese law, as well as evolving and political attitudes in China, will find this, I think, invaluable. We say it's a valuable find, but I think it's also actually invaluable. The publication date of the volume is cited at 2015. Just have a quick look at it again. Green cover at the front there, then the spine. Not very much on the back. It talks a little bit about various challenges and so forth. There's not a great deal of published commentary about this, but there's the middle of the book there. You can see the footnoting again. A lot of detail, very heavy on words. Some of the paragraphs are very long. What I did like is there is actually a conclusion to each of the main chapter headings, which I did think was of some help. And if we just go to the front again, just remind you of the preface about China's rule of law itself, and trying to get some ideas. It says, for instance, a confusion about China's rule of law might haunt Western readers. That is, in relation between the leadership and the ruling of the Chinese Communist Party, expressly provided by China's constitution and the enforcement of law. And I think that's an important point to bear in mind, because, again, you do actually have to consider this on the basis of a completely different political system that's running a country. And I think on that basis alone, apart from any other consideration, it's a fascinating area of study and a fascinating read. So I'd like to thank the author again. I hope I pronounced the name correctly, Jichun Shi, and all the people involved, which I think they've gone a long way to help us give a much better understanding of where we are in 2015 in the whole of our relationship with Chinese law and the Chinese legal system. Thank you all very much, and also to Edward Elgar. We can't do without this sort of material, because it's of great benefit to us in trying to explain difficult things as easily as we can in all the circumstances. So thank you. Bye bye.